hope my voice is perfectly audible. So yesterday we were dealing with Minimum Wages Act 1948, right? So what all things we have done under that? Let's have a short and quick review of that. First of all, this Minimum Wages Act 1948, it was introduced as Minimum Wages Bill by Dr. Ambedkar in 1946, and it was being passed as an act on 15/3/1948. Fine. And what was the objective of this act? Why this was being passed? To bring the social justice, to prevent the exploitation of worker by the employers, right? And it is being revised from time to time also. It doesn't remain the same, right? Okay. And yes, few more things are also there under this, which is like minimum wage, fair. It has under this act itself, we have learned the concept of minimum wages, fair wages, and living wages. Minimum wages means minimum wages sets the lowest limit below which wages cannot be allowed to sink. So the wage cannot sink below minimum wages, right? It is the lowest landmark we can say in terms of wages, right? And different minimum rates of wages may be fixed for different schedule employment, right? And wage period could be in terms of hour, day, month, or any longer period, right? Now, so minimum wage, this minimum wage means the lowest wage which is being paid, and it cannot sink below that. Now, fair wage is the wage which provides a bare substance, and it is little above the poverty line. Okay. So fair wage is little above the minimum wage and is sufficient to provide necessities. And the third one, that is living wage. It is like at comfort level. Fine. Is it clear? Is this much clear to everyone? Okay. Now, procedures of fixing and revising minimum wages. This is the part we have to do today. Okay, we have to start from here. Okay. All right. So let's learn about it. Now, in section 5 of the Minimum Wages Act 1948, two methods have been provided for fixation. See, I told you it is being revised from time to time. So how it is being done? Under this method, committees and subcommittees are set up by the appropriate governments to hold inquiries and make recommendations with regards to fixation and revision of minimum wages as the case may be. Fine. And notification method. Government proposals are published in the official gazette for information of the persons likely to be affected thereby, and specify a date not less than 2 months from the date of the notification on which proposals will be taken into consideration. This is how it is being revised. Either the committee is going to revise it, which is being appointed by the government, or they publish it and then you have to send proposals for the same. Fine? Is it clear, everyone? Now, payment of minimum wages and hours and all. Let's learn about this part. Okay, let's learn about this under Minimum Wages Act. Fine. So I'm just going to put it on the board itself. See, section 12, payment of minimum rates of wages. The employer shall pay to every employee engaged in a scheduled employment under him at a rate not less than minimum wages. Okay, without any deductions except as may be authorized under the PW Act 1936. Section 3, fixing hours of work for a normal working day. It should not be more than 9 hours. 1 day break should be included. This we have read earlier. The government may fix the number of hours for a normal working day inclusive of intervals of rest and payment for the day of rest. Now, the government may fix, exceptions to normal working hours. The normal working hours need not be othered in the following cases: where the persons were employed to meet emergency or urgent work, whose employment is dependent on natural factors. Okay, employs those who have not completed their duty in time for technical reasons. So these are exceptions to normal hours. And suppose someone is doing overtime, then how much they should be paid under this act? What is the provision for that? Let's learn about that. Fine. Now see, overtime wage shall be double the normal wage, right? Where a person has worked more than normal working hours for any day, the excess work hours will be treated as overtime. Where the fixed normal working hours for any days is in excess of 8 hours, we have to go by the methods of weekly worked hours. Okay, if the person has worked for more than 48 hours in a week, then excessive hours worked will be treated as overtime. Got my point? Did you got that? Everyone out there? Just few are responding? Okay, fine. Now, Section 15, wages for a person. Suppose you have not you have worked less than normal hours. What is going to happen in that case? Where an employee worked on any day less than the normal working hours due to the fact that employer could not provide the activities of the job, then the employee is entitled to receive full salary. See, if the server is down at their end and you have gone to the office, you were sitting there struggling with it, then you have to be paid. It's not your issue. Where an employee worked on any day less than normal working hours due to the fact that the employer has not worked due to unwillingness, then the employee is not entitled. So if you haven't worked because you didn't want it to, then they can deduct your salary. Otherwise, no. Fine? Now, fixing of minimum wages, and after this we are going to learn about the revision part. Okay. Alright. See, the Act contains list of scheduled employments for which minimum wages are to be fixed by the appropriate government. Section 3 empowers appropriate government to fix the minimum rates of wages in the scheduled employments where 1,000 or more employees are engaged. Revise the minimum rates at an appropriate interval not exceeding 5 years. So they have to revise it in 5 years. It should not go beyond 5 years. And appropriate government can add new jobs to under this act. Fine. Is this much clear to everyone? Okay. Now, payment of minimum wages. It should be paid in cash. Okay. The minimum wages has to be paid without any deductions other than statutory deduction. Okay. What is a statutory deduction? Anyone? What is a statutory deduction? What is meant by that? Statutory deduction. What does that mean? Yes, correct. Yes. Okay. Where the wages are paid on a piece rate, and if no wages are prescribed in the GO for piece rate, then the employer should pay minimum wages to the workers at not less than the minimum time rate. So these things are being mentioned in the law itself. Now, payment of minimum wages. The minimum wages must be paid irrespective of the extent of profit or financial condition of the establishment. Even if your company is going into loss, then also you have to pay them minimum wages. You just cannot sink beyond minimum wages. Otherwise, you will be sued for the same. You will be punished for the same. That would be considered as illegal. Fine. The minimum wages must be paid irrespective of availability of workmen willing to work on lower wages. Even if they are having people who are willing to work at lower rates, still they have to pay minimum wages. Got my point? Is it clear, everyone? Please let me know in the chat box. Okay. Now, deduction payment for minimum wages based on quantum of work done than the norms is violative of Article 23. Employees who does work in two different scheduled employments in days shall be paid based on working hours allocated to each type of job. Now, and they also, under this law, they should maintain the register in which they need to have the employee's name, address, father's name, age, gender, work performed, wages paid to them. Okay. and it should be, it should be displayed in the premises where employee works. Okay, so they have to maintain the record, and this is as per law. Okay, the other registers are to maintain a registers of fine. They should maintain a register of fine, register of deductions for damage, loss caused to the employer by the neglect, default of the employed person. Suppose due to neglect of an employee, they are incurring losses, they have to maintain the register for the same, and they can even deduct money, some amount for the same. Overtime register for workers, muster roll. Okay, the register shall be preserved for a period of 3 years after the date of last entry made therein. Fine. So they need to preserve it for 3 years. Fine. And the appropriate government, how do they enforce this law? That is the question. How does the government enforce this law? How do they ensure that this is being followed? So they have inspectors for that. Now, the appropriate government appoint inspectors to enforce act. All the officers of labor department notified. The inspectors have right to enter the premises of employers at all reasonable hours, to verify all the records as required to be maintained by law, to examine any person they find in the premises, to inquire about the work given to workers, and to get information from the employer about the payment of wages, to seize or take copies of registers. Inspectors can do that to ensure that this is, this is being enforced. This law is being enforced. The inspector shall be deemed to be a public servant. Fine. Is it clear? Is this law clear? Now, suppose they are not following it. Someone is not following it. In that case, what is going to happen? How much imprisonment they can get? How they will be punished, the employers? Let's learn about this. Like what penalties they are going to. Okay. Okay. So let's learn about this. Any employer who contravenes any of the provisions of this act other than section 12 and 3 shall be punishable with fine, which may extend to rupees 500. Any employer who contravenes the provision of payment of minimum rates of wages and hours of work shall be punishable with the imprisonment for a term which may extend to 6 months, or with fine which may extend to rupees 500, or both. So 6 months, imprisonment plus 500 rupees fine. In the case of a company, the person in charge at the time of offence happened will be responsible to discharge the liability under this act. Okay. In the case of a partnership firm, the managing partner at the time of offence, happened, will be responsible to discharge the liability under this act. Fine. So this is all about this law. Is it clear? Yeah. Very good evening, Kazi. How are you? So we were learning about, Minimum Wages Act 1948. I have already taught them that. I started up with it yesterday itself and I have finished it today. Any questions on Minimum Wages Act? Anyone out there? Any questions? Anyone out there? Okay. Now. No questions? Now I'm going to share one video with you. You can see that. Alright. So I'm going to share that with you. You need to see this video. Okay. And then we're going to switch over to the next act. Okay. You need to know. Yeah. Did you got the link, everyone out there? Please open this and see it at your end. And then we are going to switch over to the next part. Yeah, please see that video. After this, the law we have to learn about is Payment of Bonus Act 1965. So first, okay, after this we are going to learn about this. You can just increase it, Fahad. You are not able to see it properly? Okay. So just see that, and once you are done with that, just let me know. Okay, is everyone done with the same? Shall we switch over to Payment of Bonus Act 1965? Okay, so let's do it in parts. Okay, see, first of all, okay, this qualifications and all right. So I'm going to share it with you. Payment of Bonus Act was being passed in 1965. Okay. Now, what does this act say? That is the question, right? See, first of all, the object of the act is to provide certain statutory right to the employees to share the profit of the employer. Okay. Applicability of act. Every factory wherein 10 or more persons are employed and other establishments in which 20 or more persons are employed on any day during an accounting year. Certain states like Maharashtra has made this act applicable to all the establishments employing minimum 10 employees. So if your company is having more than 10 employees, you are entitled to get that. Exemption for the newly set up establishment. Newly set up establishment is exempted from paying bonus for the initial 5 years, provided no profit is made during these years. Okay. So is my voice okay, Sandeep? Sandeep, is my voice okay? Hello? Okay. Is everyone able to hear me well? Is everyone able to hear me well? Please let me know in the chat box. Is my voice perfectly audible? How about you, Sandeep? Sandeep, oh wait. Okay, all right. See, see. If it is a newly okay, if it is a newly established company and if it is not making a profit for 5 years, okay, then they need not to pay the bonus. If the employer derives profit in any of the first 5 years, okay, he has to pay bonus for that year. Okay. So if the company is having more than 10 employees, they have to pay the bonus. And if it is a newly set up company, if it's a new setup, okay, then and during the 5 years, they need not to pay if they haven't made, any profits during these 5 years. If they have made profit during any of these 5 years, they need to pay the bonus during that year to the employee. Fine? Is it clear, everyone? Now, who all are eligible for this bonus under Payment of Bonus Act 1965? Employees other than apprentice drawing salary basic plus DA up to rupees 10,000 per month. So if someone's salary is 10,000 per month, they are entitled to get bonus. An employee will be entitled only when he has worked for 30 working days in the financial year. Okay, 30 working days is 1 month. If you have worked in a particular company for like 1 month, obviously you are entitled, and if your salary is more than 10,000 up to like 10,000 per month, then you should get this. Fine. Minimum bonus is 8.33% of the total salary earnings for the financial year. Calculation to be done as if the maximum salary was rupees 3,500 per month. Fine. Maximum bonus is 20%. Now, disqualification or deduction of bonus. On dismissal of an employee for fraud. Okay, if someone is involved in fraud and they are being dismissed, they won't get any bonus. They won't be getting any bonus. If they were indulged in violent behavior or riotous behavior while on the premises of the establishment, or theft, okay, misappropriation or sabotage of any property of the establishment, or misconduct of causing financial loss to the employer to the extent that bonus can be deducted for that year. So under these conditions, they won't get any bonus. Okay, is it clear? Is it clear? Everyone out there? Is it clear to everyone? Now, what you people have to do, you have to read it from payment till 4, okay, on your own, so that you can follow it in a better manner. Don't change the board, don't move it, otherwise it is going to cause problem for others. Please don't move it. Okay, just read till 4, just read it till 4, and then I'm going to scroll it down. Once you have read all of it, then we are going to switch over to the next part. Fine. Is my voice perfectly audible, Sandeep? Are you able to hear me well now, Sandeep? Okay. Okay, great. Just read it, and once you are done with this, just let me know. Okay. Now you have to read it from fraud till each year. Okay, for that year. Read it till there. Okay, fine. Is this much clear to everyone? Do you have any questions relating to this law? Related to this law? Alright. Okay, fine. Okay, fine. Let's proceed ahead with this. Okay. Let's complete this and then I'm going to come to this picture. This is related to this law only. Okay. Sorry. I'm just going to put it here. Alright. So let me put it here on the board itself. Just wait for 2 minutes. Now, time limit for payment of bonus within 8 months from the close of accounting year. So they need to pay it within 8 months of closing of accounting year. Okay. Set off and set on as per Schedule 4, Section 15, Maintenance of Registers and Records. A register showing the computation of the allocable surplus in Form A. A register showing the set on and set off of the allocable surplus in Form B. A register showing the details of the amount of bonus paid in Form C. Filing of return. Annual return to be filed in Form D to the concerned authority. Penal provisions. So, suppose someone is not paying you the bonus, if you are entitled to get that, okay, if you fall under this law. Then for breach of provisions of the Act, the employer shall be punishable with imprisonment up to 6 months and or for fine not exceeding ₹1,000. Fine? So if they are not paying you that bonus, okay, if you are entitled to get that, if they are breaching the law, for breaching the law, they need to pay the fine not exceeding ₹1,000. ₹1,000, and they can also get an imprisonment up to 6 months. Fine? Is it clear? Is it clear? Can you please read it, whatever is there on the board, in accordance with this law? Please read whatever is there on the board in accordance with this law. We need, yes, I know it's too low, ₹1,000 is too low, but what should we do about it? Government of India has, passed that act, so you need to tell them about this rather than telling me. Okay? Let's not fight over it. Okay, they have done it, so we need to speak to them about it. Okay? And once you're done with reading, just let me know. Are you done with that? Okay. Great. Now let's switch over to that picture. Now let's learn it from here. Are you able to see the picture properly? Okay, so you can just see the picture, have a view over the picture. You see the picture properly? Okay, great. All right. Yeah. Once you are done with the picture, just let me know, please. Done? Is everyone done with the picture? Have you seen the picture properly? See, just read it properly to get the proper idea about it. Appropriate idea about it. Okay. And after this, we are going to switch over to the next act, which is, let me tell you which act we are going to do after this. After this, we are going to do the Equal Remuneration Act 1976. Let's cover that after this. Just see it properly to get to understand it in a better manner. Okay. And then after this, as I told you earlier, like few minutes back, we are going to switch over to the Equal Remuneration Act 1976. Yeah, Equal Remuneration Act 1976. Please see this properly. Just a second, please. Okay, yeah. Before that, I would like to cover Maternity Benefits Act 1961. That is a very important act. Okay, so I would like to cover that first, followed by the next one. Yeah, Maternity Benefits Act 1961. Okay, is everyone done with this? Satish, Asya, Lakshmi, Pahar, Samo, Racy, Taman, Kelvin, Ajit, Rekshi, Sandeep, Vinod, Kazi, and Asif. Are you done with it? Do you have any questions related to this law, that is Payment of Bonus Act 1965? Do you have any questions? Or is it clear to you? If you have any doubts about it, please do ask me. Okay. Now, after this, we have to cover many more laws. So after this, I would like to cover Maternity Benefits Act, which was being passed in 1961. Now, as you can see, it is for the women, okay, to protect the dignity of motherhood and to provide certain benefits to female employees at the time of childbirth, okay. Coverage of the act. Exactly. Upon all women employees either employed directly or through contractors employed in mines, factories, plantations, and also in other establishments if the state government so decides. Also applicable to every shop or establishment in which 10 or more persons are employed. Right? Now, who all are eligible to take the benefit of this? Like especially women, specifically women. Women indulging temporarily of unmarried are eligible for maternity benefit when she is expecting a child and has worked for her employer for at least 80 days in the 12 months immediately preceding the date of her expected delivery. This act shall not be applicable when the ESI Act is applicable. Benefits. leave with average pay for 6 weeks before the delivery. Fine. Leave with average pay for 6 weeks after the delivery. Fine. A medical bonus of rupees 3,500 if the employer does not provide free medical care to the women. Fine. An additional leave with pay up to 1 month if the woman shows proof of illness due to pregnancy, delivery, miscarriage or premature birth. In case of miscarriage, 6 weeks leave with average pay from the date of miscarriage. Come again. The average pay she must be getting. The pay she must be getting. And what all? See. No, what are you asking? I'm not getting your question. She is going to get the same salary, but not for whole. It's not she is going to get it for all 9 months. Okay. 6 weeks before the delivery. 6 weeks means what? 42 days. So she is going to get the leave with average pay for 6 weeks before the delivery. Got my point, everyone out there? Wait. Yeah. Is it clear, everyone? I'm going to share one PPT with you as well, okay? To get so that you can get the proper idea about this, okay? So don't worry about it. I'm just going to come to it. Let me read this and then I'm going to explain it to you properly. I'm going to answer all your questions. Fine, everyone? Now, light work for 10 weeks. Okay, non-cash benefit would be light work for 10 weeks, 6 weeks plus 1 month before the date of her expected delivery if she asks for it. 2 nursing breaks in the course of her daily work until the child is 15 months old. No discharge or dismissal while she is on maternity leave. No change to her disadvantage in any of the conditions of her employment while on maternity leave. Pregnant women discharged or dismissed may still claim maternity benefit from the employer. Exception. Now, women who are being dismissed for gross misconduct, they lose their right to get the maternity benefit under this law. Okay. Every employer shall prepare and maintain such registers, records, and muster rolls, and in such manner as may be prescribed by authority. Fine. Now, suppose they are not paying her a maternity leave if she is eligible to get that. In that case, if they are breaching for breach of provisions of the Act, the employer shall be punishable with imprisonment up to 1 year and fine not exceeding 5,000 rupees. So here the fine is huge as compared to the earlier law. Right, Samu? They need to pay a fine of 5,500 rupees. Like 5,000 itself or 5,500. Okay? And they can even get imprisonment for 1 year. Fine? Is it clear, everyone? Now, to get the clear understanding of this law, let me share one PPT with you, which I have with me. Okay, so let me put it on the board. Okay, everyone? We just need to wait for a few minutes for this thing. Okay? Is it clear, everyone? Just give me a moment, please. Okay? Is this much clear? Is this much clear to everyone? Okay. Now, let me put that PPT on the board. Okay, so that we can get the clear understanding of this. Okay. Now, let me leave it at my end till the time this is uploading on the board. Okay. See, As far as the second slide of the PPT goes, objective is being mentioned here. Maternity leave and benefit to protect the dignity of motherhood by providing complete and healthy care to woman and her child when she is unable to perform her duty due to health conditions. Okay. Now, this act, that is Maternity Act 1961, this gives her the assurance that her rights will be looked after while she is at home to care for her child. Okay. Now, who all are eligible for this maternity benefit? Like, it's not like every woman is eligible for this thing. If she is, like pregnant, must work in the establishment for 80 days in 12 months before her date of delivery. Fine. And women earning less than 15,000 may be offered ESI scheme by her employer. If she is being offered ESI scheme by her employer, in that case, she won't be eligible for maternity benefit, but will receive the maternity benefit under ESI. So if she has been offered ESI, okay, in that case, she is not going to get maternity benefit, okay? She is going to get maternity benefit under ESI. Got my point? Clear? Now, duties of employee for maternity benefit. 10 weeks before the expected delivery date. 10 weeks means what? 70 days, right? So 10 weeks before the expected delivery date, she may, 70 days means what? More than 2 months. 2 months, 10 days. Okay. So like in the 6th month. Okay. At the end of the 6th month, what she can do, she may ask the employer to give her light work, and but for that she needs to produce her certificate of pregnancy. Fine. Is it clear? Is it clear, everyone? Please let me know in the chat box. Should intimate the employer 7 weeks before her delivery date about the leave period. Fine. Name the person to whom the payment will be made in case she cannot take it herself. So 7 weeks before her delivery date, she needs to intimate it to the employer about the leave period. Okay. Is this much clear to everyone? I'll come to it. Let me finish this one first, okay? Is this much clear to everyone? Shall we proceed ahead? Now, Municipal Corporation of Delhi versus Female Workers 2000. What happened in this? I'll just let you know, okay? Okay. Union of female workers who were not on regular roll but were treated as temporary workers and employed on muster roll claimed that they should get maternity benefit like regular workers. Health. Provisions of the Act entitled maternity leave even to women engaged on casual basis or on muster roll basis, on daily wages, and not only those in regular employment, are wholly in consonance with the directive principles of state policy contained. So even those women who are engaged with the employer on casual basis or on day-to-day basis like daily wages, they are also entitled to get maternity leave. Maternity benefits, leave benefits. Fine. Is it clear? Now, cash benefits. Let's talk about this. 84 days leave with pay before. Okay. So she can get 84 days leave with pay before after delivery. Okay. Got my point? I think this is what you were confused about, right? Like how much money she is going to get. So 84-day leave with pay before or after delivery. Fine. A medical bonus of ₹1,000. Take the pay for 6 weeks before childbirth within 48 hours of request. An additional leave with pay up to 1 month. In case of miscarriage, 6 weeks leave with average pay. Average pay is not complete pay, average pay. Like your total pay divided by 12. Tuberculosis operation, leave with wages of maternity benefit for a period of 2 weeks. Fine? Is this much clear? I hope you understand what pubectomy is. Now, what all non-cash benefits she is entitled to get under this law? Let's learn about it. Okay. I will come to that, Samo. I'll surely cover that. Let me finish this first. Okay. Are you expecting a child soon? That's why you are asking about it. Why are you so curious in getting to know about it? Really? Really, Samo? Or you are just joking? Oh, that's nice. Congratulations. Okay. I wish your wife gives birth to a very healthy baby. Yeah. We'll come to that. Yeah. Now, light work for 10 weeks, 6 weeks plus 1 month before delivery. 2 nursing breaks of 15 minutes until the child, 15 minutes. Okay, nursing until the child is 15 months old. No discharge or dismissal while on maternity leave. No charge to her disadvantage in any condition of her employment while on maternity leave. Pregnant women discharged or dismissed may still claim maternity leave from employer. Fine? Now, legal obligation under Maternity Act. Let's learn about it. Is this not clear to everyone? I hope this is not boring for you. Okay. No employer can unknowingly employ a woman in establishment during 6 weeks following the date of delivery or miscarriage. Okay. No woman shall work in any establishment during the 6 weeks immediately the day before following her delivery. So for 6 weeks after her delivery, she just cannot work, and no one can hire a woman like that. If she has given, if 6 weeks has not passed after her delivery, so that means she should take at least 42 days rest after delivery before coming to work or before joining any company. Okay, shall be unlawful for her employer to discharge or dismiss her on the account of such absence. If someone is absent from the work because she is pregnant, okay, or she's or because of delivery, then and if she is being dismissed for the same, this would be unlawful. Right? Now, in case of gross misconduct, the employer in writing can communicate about depriving such benefits. So if she has done something, irrelevant, okay, like gross misconduct, okay, then in that case she will be deprived of such benefits, and employer can give that in written. That can be communicated in written. Within 60 days from the date of deprivation of maternity benefit, any women can appeal to the authority prescribed by law. Now, every employer needs to prepare records or registers for the same, right? And if they are being found guilty, for breaching the laws, they need to pay the fine of 5,000, and they can get the imprisonment of at least, in between 3 months to 1 year. Fine. Now, let's learn about one case. There was one lady, okay, what she did, let's learn about it. Now, see, Indrani filed a criminal case against company for violating the Maternity Benefit Act 1961, which forbids an employer from terminating the services of a pregnant woman unless there are complaints of gross misconduct against her. On July 26, Indrani won rupees 7.5 lakhs as settlement money from the company on orders from Delhi High Court. So unless and until she is being indulged in something irrelevant like gross misconduct, you just cannot, you just cannot give her pink slip on the, just because she is pregnant. Okay, you just cannot terminate the services of the pregnant woman unless and until she is found guilty of gross misconduct. Fine? Is this much clear? Is this much clear? clear to everyone? Is this much clear to everyone? Okay, any questions in accordance with this law? Now, let me tell you what other acts we are going to study in the coming section. Okay, see, for tomorrow, let's not do this. Instead, we are going to do something else like business English or case study. Which one you prefer? I'll go with the majority. I'm going to go with the majority. Okay, Sandeep wants to do the case study. How about others? How about others? See, we have more laws to cover under this chapter. I will surely do that, but I want to see for a change, let's do something else tomorrow rather than doing this thing. Okay, it will be monotonous otherwise, and you'll lose interest in this. Okay, yeah. So let's do some case study tomorrow, and don't forget to fill the feedback form. Okay, fine. Any questions? Anyone out there? Any questions? Okay, okay. Thank you so much. See you tomorrow. Please be there. Someone has raised his or her hand. Yeah, tell me. Yes, Kazi, what is the issue? Okay, okay. Thank you so much. So please be there tomorrow. Please be on time. Tomorrow we're going to do the case study. Some other laws are also there. We'll be covering it. Tomorrow is like, I think tomorrow is Wednesday. We'll be covering it on Thursday. Tomorrow we'll surely do the case study. Okay. Thank you so much. Okay. And don't forget to fill the feedback form. Just put genuine comments there. Thank you so much. Goodbye.